So good afternoon, everyone. I'm Andrea Barton-Rees. I'm the CEO of Connecticut's Paid Leave Authority. And with me today is Amber Forrest, who is our agency's executive assistant. So thank you for joining us for the basics of paid leave. This presentation will take probably about 20 minutes, and then we'll have time for question and answers, and then we'll give back any time that is remaining afterward, because I know we're all very busy and we're on the eve of a long weekend. So I'm going to share my screen. And I'm going to get started.
We can see your screen.
Thank you. All right. So as I mentioned before, my name is Andrea Barton-Rees. Actually, let me just do one more thing so that I'm not a distraction. Okay. And I am the CEO of a paid leave authority. I started last March, right before the pandemic hit, and before that, I was the CEO at HARC in Hartford, supporting people with intellectual disabilities and their families. And I just love it when the landscaper comes. Just the moment that we're starting, it's fantastic. All right, so now we have our agenda for today, which is just an overview of the paid leave program itself and the leave laws, the role of the employer, some of the ways in which people can apply for benefits, how it might work in the workplace, really meaning just a brief overview of the coordination of benefits, private plans, registration, where you can find additional resources, and a bit of question and answers afterward. So to start with, the authority, our primary purpose is to serve a growing need by providing financial relief to Connecticut families so that they can take time off from work to care for themselves or their loved ones without having to worry about wage replacement or lost income. So we have a twofold mission, and that's to provide accessible ways to access paid leave and to empower employers, administrators, and healthcare providers in giving them tools so that they can understand and navigate the paid leave program. Why do we have our agenda here? Oh, it's because I'm going backwards. Here we go. All right. So our responsibilities include outreach and engagement, which we're doing today, developing the policies and the procedures that are needed to run the program. We're also here to establish the trust fund and its contribution rate, which is 0.5%. We also approve and audit private plans, and we administer claims for paid leave benefits. Here are some of the key dates for the program. We started employers registering with paid leave in November, and deductions began in January of this year. To date, we've collected about $105 million in employee contributions for the first quarter. And we want to thank the 110,000 employers who registered with paid leave and submitted payments on behalf of their employees. Some employers have opted into the private plan, and we have about 260 of those employers that submitted their applications between February and March. For those employers that did submit their payments, those are due at the last day of the month following the end of the quarter on the dates that you see noted there. We will start taking applications for benefits the end of this year, and then benefits should become available in January of next year. Who is covered by the paid leave law, and actually who will be covered by family and medical leave in general? So the important thing to know here is that for all employers in the state of Connecticut, the family and medical leave law will change in total. And I'll go through that in a few minutes, but it will cover employers who've worked. It will cover employers of one or more employees in the state of Connecticut. So the employees have to be working here. And that does include not-for-profits and includes the private sector employers that have a unionized workforce. Those who are sole proprietors or self-employed individuals, they can choose to opt into the program, but if they do so, they have to stay in for a minimum of 3 years. Those that are not covered by the paid leave program include those that work in the federal government, some state of Connecticut employees, with an exception for covered public employees, municipalities and local or regional boards of education, unless they too have covered public employees, and some non-public elementary or secondary schools, all of whom are exempt from family and medical leave. A covered public employee includes those non-unionized employees of the state of Connecticut and those unionized employees who collectively bargain for inclusion in the program. Employees of municipalities or local or regional boards of education will participate if those bargaining units collectively bargain for inclusion. If they do so, then the employees of the municipality or the employees of the local or regional board of ed are included whether they are in the union or not. And you can see that there's a very, very expansive definition of what we mean by municipality. A little bit more about sole proprietors and self-employed individuals. So independent contractors are not considered employees under the paid leave law, and therefore they have the option and do not have to pay into the program. And the parties that they do work for, they do not have to withhold the 0.5% contribution. If you're an independent contractor, you do have the option to participate, but if you do so, you have to remain in for 3 years. The same rules apply to sole proprietors. They too are not considered employees. They do not have to pay into the program, but if they choose to do so, they'll do so for 3 years. The only difference here is that if a sole proprietor has employees, that sole proprietor has the option of whether or not to participate, but their employees do not. They must participate in the program, withholding the 0.5% of wages that are remitted to the paid leave trust fund. The way that works is that the employees contribute the 0.5% of their wages. That is done through their employer, or if they're a sole proprietor or self-employed, they send those in individually. We validate that information. We deposit those funds into the trust fund, and it's the trust fund that is used to pay the paid leave benefits. The contributions to the fund are capped at the Social Security contribution rate, which is about $147,000 in this calendar year. And they are post-tax contributions, and they're based on wages as calculated for the purposes of FICA for those who are employees. So a brief overview of the leave law itself. Leave can be taken for a number of reasons, all of which are captured in the statute: to create or expand your family through birth, adoption, or foster care, to care for a family member that has a serious health condition, or for your own serious health condition, which can include serving as an organ or bone marrow donor, or for pregnancy. There are special leaves available to care for a family member that's injured during active duty, known as military caregiver leave. And there's also qualifying exigency leave, so that a family member who is called overseas can take that time that they need in order to open bank accounts, make sure mortgages are paid, whatever needs to get done before the person is deployed overseas. There is time that's available for that, and that leave is covered under the paid leave law. And what is unique to Connecticut is that the leave that is available under the Family Violence Leave Act, which allows for 12 days unpaid to address any issues or concerns that arise from being a victim of family violence, will also now be eligible for wage replacement for those 12 days. So what are the eligibility requirements to receive leave under the Connecticut Family and Medical Leave Law? To receive job protected leave, meaning the ability to get your job back when you return from leave, you have to have been employed by the employer for at least 3 months, and there are no particular number of hours that need to be worked. In order to get paid leave benefits, you have to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters before leave is applied for, or I should say the paid leave benefits are applied for. You have to be working in Connecticut. The reason for your leave has to be listed in the statute. You have to have leave time available. And if you're a sole proprietor or self-employed individual who's opted into the plan, then obviously you have an opportunity to access those leave benefits through an application. So what is the length of leave and the time that you can take? The length of leave is up to 12 weeks in a 12-month period for all of the reasons that are noted, with the exception of military caregiver leave, where you can take up to 26 weeks of leave, but only 12 of those weeks are paid. 12 days for family violence leave, as I mentioned earlier, and an additional 2 weeks for incapacitation due to pregnancy. If you're experiencing a complication, you can take those 2 weeks. And those same reasons and the same amount of time are available if one is accessing paid leave benefits. You heard me mention earlier that there will be significant changes in the way that our current family and medical leave law works versus the way it will look in 2022. So whether the leave is paid or not, this still applies. So right now, all employers that have 75 more employees are covered by Connecticut's family medical leave law. If they have 50 or more employees, they are covered by federal family and medical leave as well, and they often run concurrently. In order to access Connecticut FML right now, today, that employee has to have worked at least 12 months with the employer and 1,000 hours in the time immediately preceding the time that they're taking for leave, and they will enjoy job protection after 12 months of employment. They can take 16 weeks of leave in a 12-month period, and the employer can compel the employee to use all of their accrued time, however that is measured and accrued, to cover all or part of the time that they are away on family medical leave. The law will change in 2022. So every employer that has one or more employees will now be subject to family and medical leave. And an employee will enjoy job protection after 3 months of work rather than 12. And there is no hours worked requirement as there is now with the current FML. The time to be able to take off will now be 12 weeks in a 12-month period for all of the reasons that were noted earlier. And an additional 2 weeks of leave are available if there's incapacitation that occurs during pregnancy. And while the employer can still compel the employee to use their accrued time off, they have to allow the employee to keep up to 2 weeks of their accrued leave. They cannot compel them to exhaust all of their paid time to cover all or part of the time that they're away on family and medical leave. Another significant change will be an expansive definition of family member, because it will now cover caring for a parent, a spouse, a son or a daughter of any age, or sibling, a grandparent, or a grandchild. And this is different because now the law only covers being able to take care of certain family members, and including a child who's under 18. And the only way that you can support a child who's over 18 is if they have a disability. And that will change when the law changes next year. Another additional change here is that a person who is related to the employee by blood or affinity, whose close association is equivalent to these relationships that are listed here, is also a person for whom leave can be taken if the person is deemed eligible. And that is known by related by affinity, and that definition is here. And some of the examples of related by affinity are listed here on this slide. But the one that's really most common for most people is the third bullet, where people are living together. They consider themselves to be a family. They're sharing responsibilities. This is usually under a circumstance where you are an unmarried couple, but you've lived in that relationship for quite some time. Maybe you're beneficiaries of each other's life insurance or other types of benefits. You're considered family, but you don't have a legally recognized marriage or bond. You would still, with the appropriate proof, be able to take time off to care for that other person should they become ill, and require care when the law changes in January. So let's talk a bit about benefits and income replacement. This is really focused on employees, but those who are self-employed or sole proprietors would use the same process. You apply directly to the paid leave authority for your benefits. We then determine that person's eligibility based on their earnings, the amount of time that they've worked, if they've worked in Connecticut for the 12-week period, all of the things that I mentioned earlier, and that they have a reason that's covered under the statute for seeking the benefits. We then engage in a preliminary calculation, but if the person is an employee, we will go back to their employer to validate those covered absences, because we don't want people just disappearing from work, and to calculate the offsets that any employer provided benefits may have. Like for example, if the employer requires the employee to exhaust, with the exception of the 2 weeks, their accrued time, then that is time that they should get paid for through their accruals at work. And then the remainder of the time would be time that we'd be paid for through the Paid Leave Authority Trust Fund. Once all of that is determined and established, then the authority will issue the benefit payments. And exactly how much is that? So the formula in the statute comes in two parts. The first part is for those that make less than or equal to the minimum wage multiplied times 40, which right now is $480. So that a person that earns $480 or less would receive 95% of their base weekly wage earnings. A person that earns more than that starts at the 480, and then they get 60% of the difference between what they make and the $480. But under no circumstances does anyone get more than 60 times the prevailing Connecticut minimum wage, which right now is $720. Here are a couple of examples of how that works. So Mike, we see, makes $375 a week. So he is absolutely making less than the current minimum wage times 40. So he would receive 95% of his wages. That would be $375. Deborah makes a lot more money. So she starts at the 480, and then she gets the difference between what she makes every week and the 480, 60% of that, and which is $132. So you see she ends up at $612 per week for her paid benefit. A few more facts about income replacement. A person can receive benefits from their employer and the paid leave authority at the same time, as long as those combined benefits do not exceed 100% of the employee's regular wages. So let's say that a person has access to short-term disability payments. They can certainly receive those, but they may be 60% of their wages. If they would want to come to the authority and get the remaining 40%, they can certainly do that. But again, together, that can't be more than 100%. A person who's receiving workers' comp or unemployment is ineligible to receive paid leave benefits at the same time. And I'll talk a little bit more about private plans. And I did mention a few more times about an employee being entitled to keep up to 2 weeks of their leave. They cannot be forced to exhaust it. Let me talk just a little bit about paid leave without job protection. So there are actually two sets of criteria. A person can work for their employer for 3 months and have job protection. At the paid leave authority, we determine whether or not a person is eligible for their paid leave benefit, not whether or not they have job protection. That sits with the employer. So a person could have earned the 2325, have worked for any employer in the state, but let's say they change jobs and they start with a new employer, and week one, they find out that they have a serious health condition and they need to take some time off, and they're looking to take time off from their brand new job, and they need wage replacement. The employer in that instance may say, fine, you can take it, but you haven't been here 3 months, so we're not holding your job for you, or we will, or whatever the employer decides. And that is something the employer would decide. Then the person would come to the paid leave authority, and we would say, okay, you've earned it 2325. You have a reason to take leave that's under the statute. You've not exhausted any other leave that you had before. And you otherwise are qualified. So you'll receive your paid leave benefits, but make sure you coordinate with your employer that you have a job to come back to. So let me talk a bit about private plans. The state obviously has an option for providing that employers who wish to offer a paid leave benefit to their employees can do so by creating and developing their own plan that is actually in concert with Section 31490 of the Connecticut General Statutes, which is the paid leave statute. If that's done and we approve that at the paid leave authority, the employer is responsible for all aspects of the paid leave benefit, from taking in the application, approving the time, paying the leave, anything that goes with it. While an employer is not required to remit any contributions to the paid leave authority, they can in fact withhold a portion of their wages, no more than the 0.5%, for the sole purposes of either administering the program or paying paid leave benefits, but for no other reason. And if an employer wants to do that, they also have other requirements that they have to meet, which it has to have the same or better benefits. It can cost the employees more. It has to cover everyone that works in the state, and it has to be approved by a majority vote of the employees working in the state, and that vote has to be anonymous. The next thing we'll talk about is registration. So you've heard me say that 110,000 employers have registered, and we're really just so grateful for that outcome. But in order to submit your payments, and in order for us to know that you're aware of your obligation under paid leave, you need to register your business, and that can be done as soon as you land on the paid leave website, which is ctpaidleave.org. You click on that button, get started. It walks you through the entire process, and you just go ahead and get yourself registered so that you can have an account and you can keep track of all that's going on with your contributions. Again, getting started is really easy by going to the ConnecticutPaidLeave.org, downloading your checklist, registering your business if you've not already done that. And I've talked about a lot of things today. Everything that I've spoken of can be found on the Paid Leave website, which is ctpaidleave.org. There are just a ton of resources that are there. There's 3 different ways that information for employees is organized, and you can see it as the rights poster, which is the most comprehensive document, a RAC card, which is sort of an abbreviated version, and then the fact sheets where the questions are on one side and the answers are on the other, because people are taking in information in different ways. If you have not been withholding, I'll talk about that in a moment. There is a way to kind of get caught up. And everything I've spoken about is in the employer toolkit, which can be downloaded from the employer section of the website. Now, let me talk a little bit about this employee paycheck mailer. This is what we provided in January of this year so that employers could let employees know that their paychecks would be looking different. We know that there's still a number of employers who, because of their size, because of COVID, because of all kinds of things, still haven't withheld that 0.5% starting in January. There is a catch-up period that you can use through the end of June that will allow you to take up to an additional 1% on top of the 0.5% to try to catch up in the payments that should have been taken out starting in January. Now, there might not be enough time to do that, and you can't take more than an additional 1%. So if you find yourself in that situation, contact us at the Contact Us Center, and we will try to help you, because we can work with you with the Department of Labor to get you the permissions that you need in order to be able to take out more money over time to get completely caught up. So what we're asking employers to do, and many have already done this, is to register, to make sure your payroll provider knows if that's one that you're using that they need to be withholding, which they have, to continue to educate your employees about the withholding, especially if you're going to avail yourself of the catch-up period, and to visit the site regularly for updates. And we are here to help you. We do not have a call center because they are prohibitively expensive, and we want to make sure that we use our resources as wisely as possible. You can use the contact us feature on ctpaidleave.org. It's one of the first things you'll see on the site. We have a ton of frequently asked questions and helpful videos, and the entire site and all of the documentation on it is available in English and Spanish. All right. Okay.
Thank you, Andrea.
You're
To
welcome.
our participants, I would just like to ask if you have any questions, you can go ahead and drop them in the chat or in the QA feature. We'd like to make sure that we do answer your questions. We are here to help.
Okay.
All right, Andrea, we have a quiet crowd this afternoon.
I know, it looks like everybody's ready for their long weekend, first of the summer. No restrictions, everyone's ready to go and all zoomed out, and I can appreciate that. So if you don't have any questions, we appreciate you taking the time this afternoon, actually late this morning, to be with us. You can always go to the site and submit any questions you might have, and they're usually answered within 24 hours, so just let us know. And we just thank you for your time this afternoon or this morning, and have a great weekend.
Thank you, Andrea.
All right, thanks everybody, bye.